Thank you, Madam Speaker. I am indeed pleased to rise to speak to Bill C-33, and as it addresses amendments to add sexual orientation as a prohibited ground of discrimination under the Canadian Human Rights Act. As I begin my discourse, I want to again review and put into the record what exactly it is that we feel about the inclusion of sexual orientation as a protected category in the Canadian Human Rights Act. We have considered the arguments for and against the inclusion of this term, or these words, and we take the following positions. We affirm that all Canadians, including homosexuals, are entitled to life, liberty, security of the person, freedom from discrimination, regardless of personal characteristics, and that these entitlements should be strictly enforced. We affirm that these entitlements should be based not on personhood, not on sexual orientation, or any other personal characteristics. We oppose the tendency of the courts and of Parliament to create or recognize different categories of persons in Canada for the purpose of defining or augmenting their rights under the Charter or the Canadian Human Rights Act. We oppose the practice of granting undefined or unlimited rights under the Charter or the Canadian Human Rights Act. And we oppose the government's announced intention to specifically include sexual orientation as a prohibited grounds of discrimination in the Canadian Human Rights Act as both unnecessary and inadvisable. As I begin to speak to Bill C-33, I first of all want to salute the people in this House that, Madam Speaker, I will say have stood against the tide. During the last week and a half, there has been a gargantuan task to pull together strategies in an information battle by the government and the press, a campaign of misinformation or diversion from the real issues. I state today that this government is bereft of credibility in the program that it's put before the Canadian people, and it has been driven to hide its own deficit of integrity through what it has done here. We see cheap political ploys, innuendo, and working with the media to stir up controversy rather than looking at what needs to be asked and what needs to be addressed. We see things happening that cover the fact that they've failed on their GST promise. They failed on their handling of the Somalia affair, the Creever Commission, the Westray Mine. The families and the people that are involved in that are looking to this place and saying, what are you doing? The unity debate, what have we done there? This government has failed the Canadian people in so many ways. Now, 2.5 years ago, I came to this place not to save the country. Now, many people here have certain things and certain reasons they have come to this place for. Certainly part of what was in my heart, Madam Speaker, was to address the weakening structures of our families in this country. And I say that from the heart. There is not a lot of glitz, there is not a lot of glamour in saying, I stand for family. But our families and our institutions that surround our families are fundamental to so many things within this country. The building of the importance of the family within the Canadian society is like building a wall of defense for this country. But that building can happen only one brick at a time. The wall will only be as good as the bricks that make it up. If those bricks are fractured, if they're chipped, if they're substituted with something else, we will have building blocks that will weaken the wall of defense. We'll have a wall that is open to decay, open to attack, and the loss of security of this very country. I say today, Madam Speaker, that wall built up of the bricks of families in this country is crumbling beneath us. We see it in our justice system. We see it in our economic system. Jobs, families in distress. We see it in the loss of hope of Canadians. So I repeat that the heroes of our day are those that invest their time and their effort into brick making. That is creating strong and healthy families to build this country. And those folks, Madam Speaker, are in our homes, in our communities, in our churches, right across this land. And those people are on both sides of this house, and they have stood bravely. Now today I'm pleased to express not just my concerns about Bill C-33, but convictions that I hold. First, Madam Speaker, I do believe in the equality of all Canadians. That basic principle that all Canadians are equal under all of our laws is a basic principle that defines the policy and approach of the Reform Party. It has affected many of our policies, from our unity principles of Canada, where we stand on the fact that Canada is created of 10 equal provinces under this great confederation, and there are no special rights for any one province. And that equality principle extends to the basic definitions of the rights and privileges of every individual in this country. The Reform Party and I utterly reject the definition of equality based on a listing of groups and the promotion and protection of certain categories based simply on historical disadvantage. Where in that is true equality today? The Liberal mindset is to list categories, to elevate or to look at the different rights of different people and elevate the rights of one group, which by definition is at the cost of another. For instance, we've seen the failed policies of employment equity rejected by Canadians. That is the right to hire people and to promote people based not on their ability, based not on getting the best person for the job, but based on their membership in a category, in one of those lists. I say shame on that mindset. What that makes is the rights and privileges of these individuals not equal, and in fact, some in our society become more equal than others. So the Reform Party rejects the listing of categories in the Canadian Human Rights Act and in the Charter. If we look back into history, we see that it was Trudeau's repatriation of the Constitution that brought in our Charter of Rights and brought in that first list. Just actually in listening to this debate, I learned that, it was at that time that the Charter of Rights replaced a Bill of Rights that had pre-existed, and that pre-existing Bill of Rights had no such list. But here, a man introduced a list and the impression of equality by category. I was going to say, in this debate, I learned that it was in the American Bill of Rights, and past that in history, the French Declaration of the Rights of Man and Citizens of the 18th century, there was no such list. There, equality is simply stated as a universal right of every individual in those societies. However, and that indeed is the model used for many, many countries of this world. But for whatever reason, our Prime Minister of years past decided that lists were the way to go. So because of that, that has allowed courts to pit the rights of some Canadians over others, and it has introduced a system of special rights by inclusion in that list and lesser rights by exclusion from that list. Honourable Member mentioned earlier how we could question a list. Well, great thinkers of our history in this world have done very well without a list. Now, we see this list again mirrored in this approach to the Canadian Human Rights Act. And interest groups are lining up to be included. Therefore, our party, Madam Speaker, has said that we would delete that entire list and not add another category to something that is already at fault. We believe in equality before and under the law for everyone, and equal protection from discrimination under the law that is provided in the Charter outside of any listing in the Charter or in the Human Rights Act. We believe that all Canadians should have their rights protected, including including this very right that we're discussing today, the right to freedom from discrimination. That was the first point, my first conviction, that equality for all Canadians is a basic right. The second point I want to bring up today, and the second conviction I bring to this House today, is that this government has abandoned Canadian families. The family is the foundation of society. As our families go, so will society go. The Liberal attempts to redefine it to reflect our changing times does not make sense. What we should be doing is looking at how we can strengthen this institution, not redefining it, but strengthening it. It is the basic building block of our society. It's defined through time and tradition, and when anyone attempts to alter its importance in society, that should not be taken lightly, Madam Speaker, because again, that is what will build this wall that I talked about. It is strength in our families that will lead to strength in our nations. Now today, I would like to demonstrate where this government has abandoned the family. Under the guise of human rights, it will promote the reconstruction of the basic definitions and the understanding of this basic building block of our society. It will open up a gateway of interpretation through our courts. Once this is passed here, a gateway of interpretation through the courts that will facilitate a social reconstruction that will affect more Canadians, Madam Speaker, I put to you, in more aspects of their life than we can imagine. The government has abused its power of its majority. It's rammed through this legislation, and before, or I suppose to prevent the implications from being realized, it's rammed this through in approximately 2.5 days of debate and 1.5 days in committee. And even then, that committee was loaded with pro-government side witnesses, pro-government side MPs. I say to you, Madam Speaker, this is an abuse of power, and it's deception to the Canadian people, and it's lack of integrity in the process that would address this most important issue. It was interesting in that committee, there were two people in that committee that sat on the 1985 all-party standing committee that has been quoted so often in this House. The very committee that recommended at the first time that sexual orientation should be added to the Canadian Human Rights Act. It was interesting in the discussion that the chair of that committee, who was on the committee of 1985, admitted to the committee in discussion that it was the member from Burnaby Kingsway that wrote that report. In my earlier presentation to this committee, I said that particular standing committee of 1985 went beyond its mandate. Well, I challenge this House. Who is it that authors reports from committees in this place? And why was it given to a member from a third or fourth party, I'm not sure what it would be at that time, that authored that report, which is quoted again and again as a reason we should be doing what we are doing today? Many of us were here last night. I think most members were in the House last night. And graphically last night, we saw that the lack of promises, or the avoidance of the issue was demonstrated once again. The Justice Minister has time and time again either put forward statements that I believe are misleading or refused to answer specific questions. Those issues were put to the test last night in this House. We asked him to make promises or to clarify where this bill was going in committee and within this House and within dialogue with him. What are the implications of this bill? And so last night, Madam Speaker, those that are concerned about this bill spelled out their concerns and put them forward as amendments to this bill. Those are the concerns not only of the people in this place, but of Canadians from coast to coast. Having just a few days to ask these questions, we put them forward and put it to the government to answer what it is that this bill will affect. So our concerns should be the concerns of every Canadian, and I believe they are. Now, what is the government record? We have a Justice Minister that has said that this legislation is simply a matter of adding 2 words to a very simple bill, 2 clauses. Those 2 words will prevent discrimination, and it has no bearing on other legislation. He also said that, sure, there's 8 other provinces that have similar legislation, and that has not caused any problems. Why in the world would be worried about such a thing here? Today I would like to briefly look at 4 major areas of concern, Madam Speaker. Brought up last night, and again I want to discuss them today. One question that Canadians are asking: will this authorize same-sex benefits? Will spousal benefits come out of what we are looking at in this bill today? Motion number 14 last night at report stage sought to verify that no change would be implicit in this bill in regards to spousal benefits. Motion number 14 added a new clause to affirm that nothing in the bill will result in same-sex benefits. A very simple amendment, Madam Speaker. That amendment was defeated by this government 166 to 50. Obviously, no commitment was wanted to be, the government was not prepared to make any commitment to that promise, even though they seemed to indicate it at every side. It's interesting that the Ontario Bill 167 last year, when it was brought in for a free vote, as supposedly this one is, in that bill they were at least honest enough to explicitly state that that would change benefits and change some of these things. And last year, in a free vote in Ontario, that went down to defeat. Now, Bill C-33 neither states that this will be part of the implications of it, nor has it been given any time for public discussion or debate on that matter. Again, the claim by the minister is that this bill is simply basic protection from discrimination. It's interesting. Rock wrote a memo to the Liberal MPs not long ago, and it said this amendment will not result in the extension of benefits to homosexual partners. And I'm sure Liberal members looked at that and said, good, I can go home and tell my constituents they have nothing to fear. It's interesting, though, that government officials and our Justice Minister himself have admitted from their own mouths that this will logically lead to a provision of spousal benefits. I have a quote from Max Yalden, Chief Commissioner of the Canadian Human Rights Commission, March 15th, 1994. This government official said, "We are strongly in favor of an amendment to the Human Rights Act that would prohibit any discrimination based on sexual orientation. That means if benefits are paid to a heterosexual couple, the same benefits should be paid to a couple living in the same situation, except that they are 2 men or women." And then our Justice Minister, in an exclusive interview with a pro-homosexual newspaper, is quoted as saying, "If the government takes the position that you cannot discriminate, it follows as a matter of logic that you have spousal entitlement to benefits." Now, when was it that he said this? Also, actually, in March 1994. He and Max Yalden seem to agree at that point in time anyway. However, neither are willing to admit it at this point in time, either to this House or to the Canadian public. And I would ask, Madam Speaker, if the Canadian Human Rights Act has nothing to do with spousal benefits, why is it that the majority of cases dealing with same-sex matters before the Canadian Human Rights Commission are indeed based on spousal benefits? It is those very cases that are just waiting for a decision to be made here. And it will happen.
Shameful.
The second question that every Canadian is asking, will this lead to a redefinition of family status, of marriage or spouse? Now again, last night, this was addressed by several of our amendments. Motion number 11 simply added a clause to the bill affirming that sexual orientation will not define marriage, family, spouse in any act of Parliament. Very straightforward. Motion number 21 added a clause, or suggested to add a clause, reflecting that the definition of family, reflecting a definition of family that would be understood by the majority of Canadians. And this is the Reform Party definition of family as the union of a man and woman for the purpose, the union of a man and woman, no, yikes. I'll have to, I brought the wrong piece of paper with me, I'm sorry. The definition of family, if I can think of it, Madam Speaker, is union of a man, well, no, those related by blood, marriage, or adoption, where marriage is defined as a union of a man and a woman as defined by law. That very definition is what most Canadians would abide by. It was interesting in the committee, as the Justice Minister came before that committee, he steadfastly refused to put any definition or proposed definition to the word family that is in the preamble to the bill. Now, the Justice Minister, in a press release of April 1996, said the proposed amendment will have no bearing on definitions of marriage, family, or spouse. It will simply guarantee human rights. In the committee, both myself and the member from Burnaby Kingsway, for two different reasons I'm sure, pressed the Justice Minister time and time again. Will this include same-sex unions? What kind of definition of family are we talking about? Neither one of us could get any kind of answer from the Justice Minister. I was reading the summary of Canada versus Mossop of February 25th, 1993. This particular case, again, was to do with benefits, as I've suggested many, many cases are. And I will quote from that. And this is in relation to definitions within legislation. At that time, they were looking at the definition of family status. And this quote goes, "Parliament's decision to leave family status undefined is evidence of clear legislative intent that the term's meaning should be left for the Commission and tribunals to define." It goes on to say the enumerated grounds of discrimination is a meaning, or is established so that the meaning is not frozen in time and scope and may evolve. So they admit at this time that the lack of definition for the term family status is specifically so that courts can change that definition. Now logically, I take from that, Madam Speaker, the lack of will to define family within courts leaves it, or within legislation, leaves it within the purview of the courts then, not only to define it, but to evolve that definition. It means redefinition by courts by not defining it. It's interesting, in 1993, Chief Justice Lamarck of the Supreme Court of Canada commented on the effect of the inclusion of sexual orientation in the Canadian Human Rights Act. He said, if sexual orientation had been included in this act that we're looking at today, at that time, his interpretation of the case that they just reviewed could have been that, or should, or very likely would have been, that homosexual couples would have legal family status. So, with sexual orientation in this Canadian Human Rights Act, I put to you that indeed would change the definition of family status. It would change the definition of spouse. It would change the meaning of over 50 federal statutes in relation to those definitions. The third point, Madam Speaker, will this lead to affirmative action programs for homosexuals. That, again, is a concern for many, many Canadians. Motion 18 last night made the statement, nothing in the addition of the word sexual orientation in the two sections will result in the inclusion of those terms in section 16. That was the section dealing with special programs or affirmative action. It's interesting, though, that even though specifically these words are not included in section 16 of this proposed amendment of the government, there is in section 3, which is part of what we're looking at, and those words are included in section 3. The first words of that section read that for all purposes of this act, and then goes on to include sexual orientation. So that indeed it is not only possible, probable, perhaps surely, that sexual orientation will be read into section 16. And it's interesting to note, last night the government again defeated this amendment that would have clarified that concern. It's interesting. Why is it that the words sexual orientation are now appearing on application forms in post-secondary institutions? Why is it that in this upcoming census for all Canadians, the census whereby they get the proportions to use in our affirmative action programs or our employment equity programs, why is it that sexual orientation questions will appear on the census? I ask you and I say that it would appear that indeed that will become part of the government program. Again, in the committee, we had the Ottawa Police delegation coming and admitting that they now use employment equity practices in their hiring and in their promotion, and that right now they are actively and proactively recruiting gays and lesbians for the force. It doesn't take a lot of imagination to see that becoming part of their total employment equity program. The fourth question, will individual freedoms such as the freedom of religion, expression, and association be affected? Again, Madam Speaker, I put to you that this is a concern of every Canadian. The Justice Minister, in his opening speech on this bill, gravely misquoted the Catholic Catechism in his speech. And this indeed is in terms of freedom of religion. He indeed that day spoke for religions and basically said that this particular legislation did not offend any religious or any religion, I believe. I don't have the quote right here, right now. I put to you, Madam Speaker, that in saying so, this Justice Minister made a gross intrusion and a gross misrepresentation of many, many Canadians, and in fact abused the jurisdiction of his office in saying that. I have here, and I just grabbed a few before I came, letters that from different organizations, religious organizations, that are firmly opposed to what is going on here today. The Ontario Association for Catholic Families, the Canadian Conference of Catholic Bishops, the Christian Ministers Association, British Columbia and Yukon District Pentecostal Assemblies of Canada, the First Baptist Church Nanaimo, the Vancouver Chinese Evangelical Ministerial Fellowship, the Bishop's Office of the District of Kamloops, to name just a few. How could the Justice Minister have been so blatantly wrong in making that statement? Rock stated as well that the provincial experience indicates there's been no conflicts, no real effects of implementing sexual orientation in their Human Rights Act. Just a couple of examples, Madam Speaker. In Quebec, in 1980, there was a legal case. The Catholic School Board of Montreal was forced to rent out their facilities to the Homosexual Association of Quebec. The Catholic School Board of Montreal argued that homosexuality was condemned by the church, and they, as an educational institution and as a church, had a right to resist renting out their facilities. The courts did not agree with them. A second example is in Alberta, the Queen's Bench, 1994. The employee of a religious institution was dismissed because he did not comply with that institution's policy on homosexual practice. The right to his employment was struck down on appeal. It looks, in fact, it has been said that the very movement at the federal level for introducing this term into the federal Canadian Human Rights Act has been precipitated by the fact that this provincial court struck this down, and in order to ensure that this would be the direction of courts, this particular place, that the legislation had to be done sooner rather than later. But the issue remains: a religious institution challenged as to its own choices and to its and who it would be to work with it. A third example is the Manitoba Human Rights Commission, March 1993. In Winnipeg, this case was Crippen versus the Big Brothers Association of Winnipeg. It was alleged that the Big Brothers Association of Winnipeg discriminated against this individual when it refused to match this individual with a little brother because he was gay. I would like to point out that the Big Brothers did have a policy, Madam Chair, not to match a gay with a little brother unless the parents specifically indicated that a gay man would be acceptable to that match. They did have that provision. However, that provision was not good enough, Madam Speaker. And this was challenged within the Manitoba Human Rights Commission. It's interesting to note, this was deemed to fall under the category of provision of services, which falls under the Canadian Human Rights Act, but it worked or went against the Big Brothers Association of Winnipeg. A fourth example is the BC Council of Human Rights, August 4th, 1995. In this decision, it was determined that a doctor discriminated against a lesbian couple when he refused to provide them with artificial insemination services because they were lesbians. Again, it's interesting to note, this doctor had provided this type of service to a previous lesbian couple and had been caught up in their litigation, and so had decided to withdraw himself from this kind of scenario for his own reasons. The doctor, who had previous artificial insemination litigation, argued that professionals should be able to provide services to whom they choose. However, the council did not agree with him, and so it was struck down. It's interesting, the two people involved in this litigation, Tracy Potter and Sandra Benson, are constituents of mine, and I, Madam Speaker, have met with them. And it was interesting, last year I did receive a birth announcement from them. So obviously they did find someone who would meet their need, but in the meantime we have a human rights challenge against this doctor. A fifth example, and this is to do with the effects of provincial decisions. Again, the Justice Minister claimed that what happens in the province has been fine and has no effect through the country. There was a Leshner case before the Ontario Board of Inquiry. And I'll quote, "The majority concludes that the definition of marital status be read down to remove recrimination or discrimination based on marital status by reading out the phrase of the opposite sex." And it goes on to say, "It urges the Government of Ontario to make every effort to persuade the Government of Canada to change the Income Tax Act. And if political persuasion is unsuccessful, then to take legal action." That's from the Canadian Human Rights Reporter, September 1993, or 1992. So in addition to these court cases, I'd also like to put to the Canadian public and to the members of this House, if we think, when we think of lists and categories, I think of the experience with visible minorities here in Ontario. And I am familiar with police departments that are not allowed to keep criminal statistics by categories, by visible minority categories. Now, I think it was yesterday the issue was raised. These are facts, and maybe these are facts that in fact would help society, not to discriminate against a group, but to help the whole. If there's a problem within a group, that should be addressed and should not be denied on the basis of discriminating against a group. However, last night, for instance, a member in our own party was challenged when he brought forward health statistics. What will happen if statistics, if facts, if the very things that will create decision processes are not allowed to come forward, whether it be for treatment or whether it be for funding or whether it be for anything? But if these things can be put down and made untouchable, groups made unaccountable because of this protection of this word discrimination. And what about freedom of expression? I'm aware that homosexual lifestyle is already being taught as equivalent to heterosexual lifestyle in our schools. I'm also aware there's federal involvement through Health Canada in our schools, a curriculum development through our violence initiative funding, or has been there. This government has put out a guideline to sexual health that is in every province across this country. It has outlined curriculum for sexual health, and those guidelines go from kindergarten to grade 12. Now, first of all, do Canadians know this has happened? I don't think so. And has there been freedom for parents to speak up and choose what it is that is being taught to their children, and of freedom to know of the government involvement in this area, or indeed what it is that their children are being taught, or what's being suggested by this government? In conclusion, Madam Speaker, I want to say that Bill C-33, I believe, is a gateway to an agenda of a powerful special interest group. It is not at all about individual discrimination, but it is about, and I've sought to point that out today, it is about special rights, it is about invasion of family rights and privileges. I believe that the family deserves special recognition in our society, and it's not to be tossed away lightly by a government that already has been responsible for much of its decline. In the name of progress and of openness and of rights, the family is increasingly becoming the unfortunate casualty. And in the name of community, I have a shocking quote from a government witness to the Committee on Bill C-33. There, an individual, the first Vice President of the Canadian Association for Community Living, said last week, and I had to listen to it twice, I had to read it on the transcript to appreciate what he said, and I will quote, "While we hear a great deal of lamenting of the fact that the traditional family is deteriorating, we must acknowledge that many of those changes have benefited women, children, and society at large." This, Mr. Speaker, seems to be the mindset of this government. This, Mr. Speaker, seems to be the mindset of our bureaucrats. This is definitely not the mindset of the vast majority of Canadians. I'm reminded of one of my experiences when I was in China. There, I went to visit the Great Wall of China. And the people of China, I found, wanted security behind this wall for the barbarian hordes that lived to the north. They built this wall, and it was so high that they thought nobody could climb over it. And it was so wide that they were convinced that no one could break it down. It was an awesome sight to look in both directions as far as the eye could see and see this wall snaking across the top of the mountains, wide enough for a chariot to drive across. Even today, they say it's the only man-made structure that's visible from outer space. And it's not surprising that the Chinese then settled behind that wall, secure in their accomplishment. But it's interesting, Mr. Speaker, during the first 100 years of that wall's existence, China was invaded 3 times. Not once did the barbarians break down the wall, nor did they climb over it. Every time, of the 3 times, they bribed the gatekeeper and marched right through those gates. The Chinese were busy relying on their wisdom and accomplishment, and they forgot the importance of integrity. The process that we have seen here in the last few days is bereft of that integrity. It's true that integrity won't come from edicts and legislation. Governments, try as they might, cannot legislate the moral fiber of the nation, but governments and laws that are made can and do have a profound effect on those institutions which are the bedrock strength of this society. Integrity is the most important single quality for any individual or nation, and it's born and thrives, Mr. Speaker, in the bosom and example and the conversation of the homes of this nation. To blindly reorder society's foundation, that is the home, is to threaten that nation's future. Our future lives in the institution of family and of faith and of our cultures. The lawmakers that deny or attempt to disregard the fundamental necessity to safeguard these historic institutions will eventually, I put to you, they will eventually undo the fabric of this nation. Now, I would like to move today, if I may, Mr. Speaker. I would like to move that, in relation to Bill C-33, that all the words after the word "that" be deleted and the following substituted therefore. Bill C-33, an act to amend the Canadian Human Rights Act, be now read a 3rd time, since, as assigning special categories to certain groups in law, this bill does not seek to uphold the principle of equality to all Canadians, while at the same time it fails to ensure that the current legal definition of marriage, family, and spouse in federal statutes and regulations will not be altered, and that fundamental freedoms in society will not be infringed upon. Thank you, Mr. Speaker.